pretty outside?
These are bluebirds.
Bluebirds?
Yes.
What does that mean?
Oh, you're showing your age.
Oh, no.
Showing my age. The bluebirds are the elites, right?
Oh, the
The
elite.
sparrows are
Okay, the
ones that
sparrows.
don't come.
Okay.
Anybody got an extra handout?
Yes, we do have extra handouts right here. How many do you need?
Two.
Here. There you go.
Yeah, some of us are just vulgar.
You need another one too? Sure. Thank you. You're welcome. All right, guys, how is everybody today? Oh, I didn't hear. How is everyone tonight?
Great, fantastic.
You need to stay awake with me because I drove up all the way up here, so I'm going to expect each of you to be engaged and involved in this discussion. It is a smaller class, so it's perfect for you to bring up your own specific questions and whatever issues that you have as we're going through the presentation. I have my own sign-in sheet that I'm always supposed to get as well, so could I have you guys give it to each other, and I'll start it here and then just make sure it gets all the way to the back? Thank you. You got a pen, all right. Okay. So how many people have never been to any of my classes before? Okay, just one or two. Not been here, yeah, only one then. All right. Well, as you know, I present classes all through Colorado, and I come to Fort Collins maybe 5 or 6 times a year. And what we try to do is capture topics that seem to be relevant to most associations. And we create our curriculum really based on what we hear from you. So to the extent that you can provide any comments and feedback or what you want to hear about, you know, if you're a subscriber to our newsletter or if you get on our website, you can always, or send me an email or something, let me know. My email is at the last page of the PowerPoint slide. But tonight what we're going to talk about is homeowner rights and responsibilities. And this is something that doesn't often get discussed, but it's something that is important. And what we're talking about is not necessarily just the board of directors' obligations, which is a lot of what I focus on because most people in my audience are board members. In fact, how many here are board members? Raise your hand. Okay, all right. Well, what doesn't really get discussed is the responsibilities on the other side as well, because it's a two-way street. Not only do board members have obligations to act in a certain way if they're board members, to make sure their decisions are done according to a particular standard, but also homeowners who are in community associations also have their own obligations to act accordingly. And if you look at the, let me just get through this first slide first, because I always start with this, but the second slide we're going to talk about rights and responsibilities and where this came about. But first of all, what is a community association? I always start with my classes with this because I want to make sure, especially since most everybody raised their hands when they said they were board members, that you remember, if you're a board member, you have to take off your homeowner hat because you have several other roles that you play as board members in the association. And the community association is made up of a number of things. And I always get board members that forget, you know, as soon as they get on the board, they may have gotten on the board for a particular issue or an agenda, but once they get on the board, they have to remember that they act under certain standards. And the first one is the association is a nonprofit corporation. That means that the association is subject to nonprofit law. So how many of you have actually read or reviewed the nonprofit code that's applicable? Oh, look at that arm that goes up, so proud, you know, that you're rare, actually. Anyone else actually looked at the statute? Not Kiowa. I know a lot of people know about Kiowa, but the nonprofit code. Okay, so we have other classes that talk about the various governing documents and laws that apply to associations, but nonprofit code is one of those laws. Yes.
Is that accessible via a website?
Yes, it is. On the last page of the PowerPoint is our website.
Okay.
And there's a little search area on the website, and all you have to do is type in nonprofit code or nonprofit act. It'll come up right away.
Thank you.
You're welcome. So community associations are subject to nonprofit codes and nonprofit laws. community associations are also businesses, and that's a big deal. A lot of associations, a lot of board members, they're in charge of millions of dollars. You are in charge of preserving the assets and making sure that you're spending the money wisely. So it's easy to forget that when you get into the role of a director and you're mainly potentially just enforcing the covenants and not thinking about the fact that there's a lot of money involved, and especially these big ticket items, they get scrutinized. And so definitely you're wearing a hat, a business person's hat. Third, it's a community, which means that when an association is formed, they're formed for it's called the common interest community. That's what the entity is called. And when your association is formed, it's supposed to be formed for common interests of that community. Do you have any more slides, Catherine? I mean, any more? Or we just
Yeah,
have
sure do.
Okay, we just have another person that just came in. So just remembering that you have to keep your finger on the pulse of what the community wants. Because as a board, oftentimes you're acting in a vacuum. And that's because a lot of homeowners don't attend board meetings. I mean, you tell me, do you have a lot of homeowners attend your board meetings? Does anybody have that? I never get a resounding yes whenever I ask that question. Oftentimes homeowners will come to the annual meetings because that's where they vote in the board and they talk about the budget. But board meetings, there aren't too many homeowners that attend those. So you got to keep your finger on the pulse of what the community wants. You don't want to act in a vacuum, but sometimes you're required to do so. So what you need to do is continuously provide the opportunities for people to come to the meetings, to respond to proposed actions, over-communicate through newsletters and those kinds of things. And then finally, it's a neighborhood. And I always put that down because at the end of the day, you're enforcing against your neighbors. And sometimes you have to make really difficult decisions. And sometimes we have board members that may be affected emotionally, or it's very difficult for them to make these decisions and enforce against their neighbors. But that's what you're tasked to do. When you get on the board, you take off the fact that you're a homeowner and you're a neighbor, and you remember that you still have to enforce, but at the end of the day, still try to build community. And it can be difficult, but all of these hats have to be juggled. And the one hat that you're not wearing is the homeowner hat, where you are looking for your own homeowner interests. All right, so the reason why we put this class together, we've taught this a couple of times. It's been a while since I've taught this one. But how many of you have heard of Community Associations Institute? Okay, so I really encourage you to look this entity up online. CAI is a national resource. There are 2 chapters here in Colorado, one Rocky Mountain chapter and one down in Colorado Springs. And what it does is this entity provides resources and best practices and opportunities for board members, homeowners, potential board members to come to classes, to come to events, to come to showcases, to learn more about their responsibilities and how to be a better community, better board member. So CAI has been around for quite some time, since the 70s, I believe. And what they did was, this is probably earlier than the 70s, but this article called Rights and Responsibilities for Better Communities was drafted several decades ago. And what it attempted to do was list a number of things that associations, homeowners, and board members should know when they are in a community association. And it encompasses the concept of a two-way street. Not only do you have the right to do X, but you also have the responsibility to attend meetings. You have the right to use the common areas, but you also have the responsibility to maintain your yard. So it tries to balance the interests of both homeowners and board members and just association leaders. And what I did for this class was there's several things on this article. It's just a checklist of things to consider. And there is a handout that you can take when you leave the class tonight. There's some on this side and some on that side, which includes all of the rights and responsibilities that CAI has put together. But what I thought I'd do tonight is go over some of the main ones and go over some of the legal obligations and issues and concerns that come up with each of these rights and responsibilities. And that's what we're going to go over tonight. Now, as we're going through this, please, this is a small class. Raise your hand if you have any questions, if you have any questions about your association that are pertinent to the topic I'm discussing. And we'll try to answer those questions as we go through the class. Remember that although I'm teaching this, I learn a lot from my audience. I mean, I can tell you what the law is, but it's best to hear how it plays out in communities so I can figure out, well, as applied, does this really work for a particular association? So please raise your hand as we go through this, okay? All right, let's go to the first one. So let's see. Homeowners have the right to participate in governing the community association by attending meetings, serving on committees, and standing for election. I want to talk about each one of those. So participate in governing the community association by attending meetings. So meetings in itself, it has been focused on by the Colorado legislature over the last 10 years, meetings and any other opportunities for homeowners to know more about the community, know how it's run. And there's been changes in the law that concern meetings to show that the legislature is really concerned with transparency. Because the spirit of Kiowa, I asked who had heard about nonprofit code, but what about Kiowa? Who has heard about it or read it? Kiowa is the Colorado Common Interest Ownership Act. CCIOA, Colorado Common Interest Ownership Act. If you are on a board of an association, you need to review the statute. That's the overall governing statute that governs community associations in Colorado. And the reason why it's important for you to review it and know it, and it's on our website, so you can get on our website and get it, is because a number of provisions in Kiowa actually supersede what's in your governing documents. So you could be being the best board ever and enforcing your provisions to a T, only to find out that that provision is no longer valid and you're actually acting illegally. That's what you don't want to happen. And so much of the statute over the last 10 years has been changed, the Kiowa statute, to promote transparency. So the first thing that we want to discuss is meetings. What happened in some associations was that the boards weren't allowing homeowners to attend board meetings. And they are also not complying with certain notice requirements for homeowner meetings. So let's talk about both of them. First of all, let's talk about homeowner meetings. Now, you tell me, what do you do for your annual meeting? What kind of notice do you send out, if any? Ah, there's a chuckle. Why was there a chuckle?
Well, this is a new organization.
Okay.
We have the builder, there's two of the builders are on the board.
Are still on the board. Okay.
One a resident.
Okay.
And so what came out from the management company was just a little blurb that was on the Condo Cafe, which is where you go pay your bill, that just said, meeting.
There's a meeting coming up.
Right, meeting coming up in the date, and it said, I'm in Riggin Farm at the barn. And nobody saw it except the very newest people who were just moving in, because they're
Okay.
the ones who were setting up their automatic payments, right?
Okay.
And they're going, is that the barn up at Jessup?
And you're like,
So-
well.
Then
So
I
was
said,
that for an owner's meeting? An
that
annual meeting?
apparently is an annual business meeting, is what we
Okay.
have come to
So
find out.
that's what we're concentrating on now, not board meetings. So that was the notice that was provided in your association on the Condo Cafe.
Correct, until I sent like several emails and said, you know, nobody knows what this is this just an information meeting? I
Sure,
mean, nobody
sure,
even
sure.
knew it was a board meeting.
Okay, so if it's a board meeting, that's separate. So what about annual meetings? Yes,
We'll send out one email
okay,
reserving the date. A second email goes out with all the attachments, the agenda, the budget, topics,
whatever they're gonna be reviewing.
And then we mail a
considering.
packet to everybody that has the agenda, the budget, and all that sort of stuff.
So
And
you
we
do
ask for a response, are you going to be attending? If not, please fill out the proxy that's included in that packet.
Okay,
And then if we feel like we're not gonna get 2/3, we start knocking on doors.
say, please come to the meeting or please give your proxy.
Correct.
Okay, so you said email, and then what was the second
Well,
step?
there's two emails.
Two
One
emails
is just a
and then a
reserve
mail.
the date that
Gotcha.
goes out in
Gotcha.
December.
Save the date, 'cause it's so exciting, the
Yeah.
annual meeting's coming up, save the date, you
Kinda like a
know?
wedding, you know.
Yeah, well, I think that's great, that you do that, that the process of notice. Anyone else email? Okay, who just mails? Okay, so, this is what the law says. So initially, what your bylaw, first of all, what your bylaws say, and your governing documents might have the new law in it. But what your governing documents usually say is you have to mail out notice to all the homeowners. That's what the documents usually say. What the statute says is you can mail or personally deliver. So that's difficult for huge associations. They don't want to, because you're gonna have to get somebody to sign off on the notice. But if you don't personally deliver, you have to mail. So if you're emailing and not mailing, that's a problem. So that's number one, mail. Now, how many days' notice do you think that you give for these meetings?
14.
I was told
14?
14.
14? 3 weeks. 3 weeks, okay, anyone else? So what the statute says, as a minimum, it's 10 days, a minimum. Now, that's what the statute says. If your bylaws provide more notice, you follow your bylaws. And many of them will say 14 days. Not many, some of them will say 14 days, some will say more. But if you have any bylaws that say something less, like 5 days, that's not valid, because the minimum notice is 10 days. Now, what about maximum notice? How soon can you send out a notice? I mean, how many days prior to the meeting? Does anybody have a cap in their documents? No. Okay, so look at your documents, because sometimes they do have a cap, but what the statute says is no sooner than 50 days. So it's a 10 to 50 day range. Just make sure that whatever your bylaws say and whatever your practice says is consistent with that range. Yes,
So
sir?
the mailing has to be within that
The
range.
mailing.
But conceivably, the association could post an annual calendar in January
No.
that would list anything and call it just a calendar, not
Nope.
notification?
No, that would be something that would be encouraged, but it would not meet the statute.
Well, that's what I'm saying. You can do that. You have to mail within that window.
In addition to.
Yes, that
Not
would
in
be
lieu
in
of.
addition
Yes,
to, not in lieu
absolutely.
of, but that would
Absolutely.
be, that's acceptable.
Over notice is great.
Okay, great.
Okay,
Yes, yes.
but this is the minimum, and the notice, if you're going to be mailing or personally delivering, has to at least be 10 days and no more than 50 days. Now, that's just number one. This gentleman here also said he emailed the notice, 2 notices, save the date, and then an email of what's coming, hard copy. Anybody email?
This email is not the same as personally delivered.
That's correct, that's correct. Email is electronic mail. So here's what a lot of associations don't know. Email notice is required if a homeowner requests it and you have the ability to give email. So this is only upon request and if you have the ability. And how many here have a management company? Okay, most management companies, they use email a lot. So if you have a management company, you absolutely have the ability to email. Now realize the email notice is in addition to, not in lieu of, just like yours, the mailed notice. So if any homeowner requests email notice, you have to give that as well as the mail notice. How many of you post notice anywhere? Other than the mailed, of course, and then the email if somebody requests. Yeah, you post it anywhere?
We post it on Nextdoor.
Okay, so on some kind of online mechanism, maybe a website, all right. So here, anyone else posted anywhere? Physically or on a website?
Sometimes on the door.
Sometimes on the doors of the
Doors of the
units,
building.
okay, or the buildings. So, here's another law that apparently no one knows in this room. In addition to the mailed or personal delivered notice, you must post it physically somewhere in the community, at least 24 hours prior to the meeting. Now there is wiggle room here because it'll say if feasible and practicable, but there's always somewhere to post this notice. You can just post a little sign in a little grassy patch area somewhere, or you can post it on the building. Yes?
Two questions. One, can it be posted on our website?
Good question. That comes up all the time.
And the second thing is if it's just a board meeting
Uh-huh.
as opposed to an annual meeting.
We'll talk about board meetings in a second. Right now, we're just talking annuals.
Okay,
So,
gotcha.
can you post it on the website? What do you guys think? As satisfying the requirement to physically post it? This comes up all the time. I probably led you into that, yeah. No, you can't. So you have to physically post it in the community somewhere. But what the statute says is we encourage also posting on the website, but you're not required to post it on the website. Yes?
Part of the problem I have with that is we have 34 patio homes,
Uh-huh.
so we don't have any common area other than just grass and,
That's what a lot of associations do, and what the statute says is somewhere conspicuous, so stick a little sign in a grassy patch.
okay, the problem I have personally with that is they take a whiteboard and they write it on the whiteboard and say, we're meeting at the library on such and such a day at such and such a time.
Right?
Well, then everybody who drives through the community knows
Knows.
we're not gonna be home then.
I agree with you, and that was actually discussed in the legislative notes, but it doesn't matter.
They don't care.
They don't care. They say 24 hours prior. So it's not, don't post it maybe like a week ahead, but I get your concern. I do get your concern, but the legislature also said, if practicable and feasible. I think it's always practicable and feasible to meet the statute, but I get your concern, and it was discussed, and they still said, this trumps. We want people to have notice of owners' meetings. Okay? All right. So, yes.
Does the post office allow you to put that notice on their box?
No, not in the mailboxes, no. But there's usually like a little area next to it that you could probably stick a sign there for just a short time. So let's talk about board meetings. So we were just talking about owner meetings now. So board meetings, do you give notice of board meetings to owners, not to board members, but to owners? Does anybody do that?
Sometimes.
Sometimes, okay. So is there a particular, because you think there's a hot topic and you want homeowners to attend, maybe?
No, we post it on the website.
Okay, all right. So here's what the law says. There is no requirement to physically or post or mail or email notice to homeowners of board meetings. But the statute also says that homeowners are entitled to attend board meetings. So it's a bit counterintuitive, but what they were trying to address is the fact that it's expensive to be sending out notice, especially if it's a mailed notice every month for a particular board meeting. I know at some point it's come up a number of times in the legislature whether you could just email notice, but at this point there's no law that requires you to. But to keep with the spirit of the statute, many associations will post it on their website. Will post the calendar of board meetings and homeowner meetings somewhere, because it's intended to give homeowners an opportunity to observe. And hopefully, if they observe the decision-making process, that will eliminate or at least minimize future challenges to decisions, because they know that you're not just making decisions willy-nilly. You're really discussing it and hashing it out, and that's the purpose of the statute. So I would say, even though it's not required, you should post it somewhere or try to give notice somehow to homeowners. Yeah.
Our board, I've read Kiowa, so I know what the statute says.
Mhm.
Our board says we don't have to tell you when there's a meeting, we don't have to provide you with an agenda.
Okay, well, that's not
It's
true.
not true.
That's not true.
And
They-
so I
yeah.
went to a meeting and they made me sit at the back of the room and not speak. And that was a violation.
Well, that's the second thing I was going to talk about, because the meetings, we're really going in depth into meetings because the statute did address that.
Right.
So you're not required to proactively send out notice, but if a homeowner requests, when's the meeting, you must tell them when the meeting is. So that's a distinction between sending it out ahead of time and somebody requesting you for that information. To the extent that an agenda is prepared for the board meeting, it is supposed to be made accessible to homeowners. Now, some board members don't even have an agenda, so I'm not going to say that and I don't know how they conduct business, but to the extent that an agenda is available, you are supposed to provide that and have it accessible for homeowners who want to attend the meeting. So that was the issue. The third thing you brought up, I bet a lot of homeowners or board members don't know. Participating in the board meeting itself. This law came into effect maybe 5 years ago. And what it says is, if the board is going to take action at a board meeting and homeowners are present, then the homeowners should be given the opportunity to speak for or against or discuss that proposed agenda item that they're going to vote on before they actually vote on it. So for example, if they're going to vote on whether or not to hire a management company, if homeowners are present, you are required to open it up for discussion and allow whoever wants to speak about it to speak for, a certain amount of time, reasonable period of time. Now, if you have 100 people there, you're not required to allow every single person to speak. You can be reasonable and say, we're gonna pick 10 people and have them be their spokesperson. But if there's 3 or 4, you give them each an equal period of time to speak on that issue. Yes?
Might be getting ahead of the script here, but we allow the homeowners to speak, but prior to the vote, we ask them to leave.
You can't do that.
Cannot do that?
You can't do that except for certain things, and I'll talk about that in a second.
Okay.
So, and that's what happens quite a bit actually, and so I want to dispel some of the myths and some of the practices, because this is contrary to what the statute says, and you need to be really technical with the statute. So, when you hold these open to the homeowners to discuss is up to you. You can do it at the beginning of the meeting and say, okay, this is on the agenda, so everybody speak now. Or you can do it right after you make the motion, and then you open it up for discussion, as long as it's before you taking the vote. But if you do it at the beginning, and everybody has their discussion, you can then stop the participation throughout the rest of the meeting, but you can't tell them to leave unless they're going into executive session. So there's only, and that's later on in the presentation, but there is a particular time when you can have people leave. So, just realize that, see how detailed the statute has gotten in 2 meetings, because they want to provide more opportunity for homeowners. Okay, serving on committees and standing for election. Serving on committees, did anybody use committees here? Okay, what kind of committee?
We have a special assessment committee.
Okay, so some kind of budgetary committees.
Right, we have, like a newsletter. that
Okay.
goes out.
That's
It just-
great.
It just
So
depends.
depends on the task and,
Yeah, it
okay.
depends on what's happening.
Okay, anyone else?
Architectural review.
Architectural review, so that's probably the main one, but it's nice to hear that even though architectural review is usually the only one that's specified in the governing documents themselves, and it's usually a requirement, not something that you can have but is required to have, but other committees, you absolutely should use them in order to get more buy-in, more ownership from the owners over whatever the project is, whether it's assessment or a social committee or a budget committee or whatever. It's a great way for the board to allow others to be part of the decision-making process. And so what committees do is they essentially get the information and get all the input together for the board to review and vote on it, or they're participating in some other way. It's up to you how to determine what the scope is, but definitely use committees if you haven't before, particularly because it's a lot of work on the board's shoulders. I mean, it's almost like a second job for a lot of board members, so if you can get people to participate, that's great. Okay, standing for election, the last one. So the only thing I want to talk about with respect to election is that sometimes we get the question of whether or not a homeowner is even entitled to run for the board. Now, if I ask you right now, is there any time that a homeowner is not allowed to run for the board? Does anybody have an answer for me? Yeah.
If they're in arrears for their dues.
If they haven't paid their assessments, okay. Anyone else? Okay, so be careful, because although you have to have the authority to suspend somebody for running from the board for delinquent assessments in your documents themselves, there actually has to be language saying you're not eligible to serve on the board if you're not in good standing, or if you're late on your assessments, or many of them say, or other violations of the governing documents. So it's not just assessments. But if you don't have that authority in your documents, they're entitled to run. Doesn't matter how late in their delinquent, in their assessments they are. Yeah.
We had I wasn't there, but this is what they passed for secretary.
Uh-huh.
The, husband, or the homeowner's significant other who's not on the homeowner deed
On the deed, okay.
is now.
Entitled to run, right?
They elected her as co-secretary with,
Okay, so secretary is a little bit different, officers are different from board members, we'll talk about that in a second. But when I asked the question of whether or not somebody would not be able to serve, the answer I got was because of delinquent assessments. Now, many associations and boards just assume that if you're not an owner, you can't run for the board. You'd be surprised, probably, I don't know, 60% of the bylaws that I see do not require you to be an owner to be on the board. So you have to look at your bylaws for the qualifications section. Sometimes it's called eligibility for serving on the board. And if it doesn't say that you have to be an owner, anybody can serve on the board. Yeah.
my bylaws say that you have to be
A record.
homeowner in the to be a part of the association, to be elected to the board.
Yeah.
What does that mean?
Yeah, if your documents require it, which a lot of them do, then you can prevent non-owners from serving on the board.
But they went ahead and,
But you're saying officer, so it's a little different.
is it different than?
It is different, so we'll talk about it in a second, yeah.
That's my question. Could you please clarify the distinction between
Board member and
officer
officer?
and board?
Absolutely,
Yes.
absolutely. One other second though, and then I'll
Okay,
get to
sure,
that.
yeah, great, great.
If you want to have, and many of the documents don't say that board members have to be owners because usually they're the original documents, and usually the developer that put them together was thinking about things like, I want my employee to be on the board, and so that language is standard, but it's often amended out later. So just consider amending it to incorporate whatever qualifications you want. It doesn't have to be necessarily just that you have to be an owner, but you might want to say, they're not delinquent in assessments, they are not in violation of the other documents, they are not suing the association. I mean, all of these things, some of them, they're not in some kind of a dispute with the association. Because if somebody's suing the association and they're on the board, but there's nothing that says that they're disqualified for serving on the board because they're suing the association, they stay on the board even during that lawsuit. So just realize if you're in the neighborhood of amending your documents, you might want to consider this. So the difference between board members and homeowners, or board members and officers. Board members are elected by homeowners to serve on the board of directors. You'll see in your bylaws that they're divided. There's a section on board members and there's a section on officers. So homeowners elect the board members. Board members then appoint who serves the officer positions, and they're usually named as president, secretary, treasurer, vice president. They vary in distinction, but all these are positions of office. They're not voters. They're not voters on the board unless they're also board members. Recognize that some bylaws will say you have to be a homeowner to be a board member, you don't have to be a homeowner to be an officer, and you don't even have to be a board member to be an officer. So be very, very clear. And the reason why I'm thinking is because oftentimes you want to be able to use the talent of others that are in the community that don't necessarily want to be on the board. For example, a treasurer. You might want to have somebody who has accounting experience, be an officer, and provide the officer role and perform the roles of the officer, or of the treasurer, but not vote on board decisions. 9 times out of the 10, the board members also serve as officers. So I'm not saying that it's usually divided. All I'm saying is your documents drive this, and many of them say that officers don't have to be board members. Yeah.
So if an officer is a homeowner as well, they can vote. If they're not a homeowner, they cannot.
Yeah, an officer can always vote if they're a homeowner on homeowner votes.
Right.
But the officer can't vote on board votes for board actions unless the officer is also a board member.
All right, you know, we've had over the years, we've had a lot of issues getting enough people to vote for board members.
Yeah, yeah.
And
That's common, unfortunately.
We've had some real lax boards in the past, so we really don't know what we are.
Okay. All right. Well, that's why you call us, and we'll help you maneuver through it. Now, and believe me, most board members don't realize the difference because you're coming into it with a long line of history of board members who are also officers, and that is typical. I'm not saying that you should change that dynamic. I'm just saying that be aware of what your bylaws say. And oftentimes the reason why this becomes significant is if homeowners or board members want to have non-board members assist in some way. Maybe it's a co-secretary, maybe it's a treasurer, maybe whatever. And they think that they can't because they're not board members. So just realize it's there.
Well, can we
All right, yeah.
back up to this lady's question? What's the definition of homeowner?
Okay, so that's defined in your documents. It's different for everyone. So most of them just say record owner. And if it says record owner, you have to have your name on the deed. If
So
you're
a
the
spouse doesn't,
no, that's not a record owner unless the spouse is on the deed. Now, today's world, we want to be able to get whoever to be on the board as long as they're living there.
Breathing?
Yeah, we usually don't have enough people who want to serve. So many associations will amend their bylaws to say, in order to be qualified to serve on the board, you have to be an owner or the spouse or significant other of the owner. They're trying to accommodate that gap. But if you're not on the deed and your documents define owner as record owner, then you are not entitled to serve on the board, but you might be able to be an officer. That's what usually happens. All right, yes,
But then who can vote at an annual meeting?
homeowners.
Only the homeowner.
The record owner, or they can give their proxy.
Right, and I think I read that it said that a homeowner could give a proxy to their renter.
A homeowner, statute says homeowners can give proxies to whoever they want. It doesn't even have to be somebody living there. It's your bylaws that will dictate otherwise, but most bylaws don't even say anything about proxies. So realize you can give your proxy to your management company, you don't want to do that. To your attorney, you don't want to do that. You want to give it to somebody who's going to be at the meeting, because the sole purpose of that person is to vote on your behalf. Okay? All right, let's move on. So number 2, access appropriate association books and records. I'm just going to tell you that I'm going to name a couple of things, but it says appropriate books and records. The law, and by law in this respect I mean Kiowa, not the nonprofit code, but Kiowa was revised 3 years ago, I think 4 actually, to change the record statute. And I'm gonna write this statute, this number down, because this is what you need to know about books and records. Under Kiowa, the appropriate provision is 38-33.3-317. That is the provision in Kiowa that addresses records. You really need to look at this because they changed it completely. Prior to this law coming to place, what the statute said was homeowners have the opportunity to review financial and other records and did not define what other records meant. So that was kind of a problem because boards thought, well, other records mean all records, because what is it? So what this statute did was provide a list of, number 1, the sole records that you're required to keep open for inspection and access by homeowners. Number 2, the list of records that you are allowed to disclose. It's your discretion, and there's some other factors there too. And number 3, the records that you cannot, that you must withhold from homeowners. So just recognize that it's been changed significantly, and you ought to know this because records requests come all the time, or your management company ought to know this. And what you're required to have, this is per statute, is an inspection of records policy in place. Now that policy, if you have a management company and they're worth their salt, they will know what I'm talking about. The inspection of records policy is one of the 9 policies that's required to be adopted by boards, and this particular one is very important because it not only tells you those lists of records, but it also tells you how the records are required to be requested by homeowners, the time frame that you're supposed to provide, things that you can request, such as, for example, if they request, hundreds of documents, then you can require a deposit for the copy of those documents. So that's one example. Also, the fact that they have to state with reasonable particularity the type of records that they want to review. So this policy and this part of Kiowa is key to, again, complying and complying with the statute and making sure you're not exposed to liability as a board member. Yes, sir.
Might the contract between the homeowners association and the management company be considered proprietary or?
Good question. So, records, remember there's a list of records that are supposed to be kept open for inspection and copy. One of those records is the agreements, the contracts of the association that are current and contracts that are that were in place 2 years prior. So you have a 2-year range, even though it's not current, and then you're outside of that contract, as well as current contracts. That includes management contracts. So management contracts are open for inspection and copying.
Is that available, written somewhere? Our management rep said that that is proprietary.
It's not, they're wrong. So look, it's in that statute I just quoted to you.
Thank you.
It says contracts, it doesn't exclude management contracts. Okay, prudent expenditure of fees and other assessments. So again, we're talking about homeowners are entitled to this. The only thing I want to say about that is, you know, here's the rule of thumb when it comes to any kind of decision, and usually it's the monetary decisions that are scrutinized the most and challenged the most by homeowners or by anyone. So prudent expenditure is, the standard is that the board has to act in good faith and reasonable and prudent, so they have to exercise due diligence. But just remember that prudence also means you have to follow your governing documents. So how many here have governing documents that are over 15 years old, 15 or 20 years old? Okay. So the newer ones are pretty similar and they have the statutory language in there. Some of the older ones are very particular in terms of caps on assessments, or what you can use assessments for, what you can use your reserve for, what kind of homeowner approval is necessary for a special assessment. So the prudence also means you have to know what kind of limitations are in your governing documents. But the general rule of thumb for board members is, unless something is specifically reserved to the homeowners for a vote, the board votes on it. That's a lot. So the board has a lot of power. Because what do homeowners get to vote on? What are some of the things that homeowners get to vote on?
Board members.
Budget, board members, maybe amending the declaration, certain amendments, potentially special assessments, it depends on the documents. Conveying common area is another one. Very few actions are reserved for the homeowners. You put your trust in the board to make those decisions on your behalf. So when it comes to expenditure fees, that's wrapped into it. As long as you're acting in an informed manner within the limitations of your governing documents, it should be deferred to, and it should be upheld if it's challenged. Okay? Yes?
This is kind of odd. The association had the meeting and kept postponing the annual meeting until I was gone, so I didn't get to.
Until you were gone?
And, well, yeah.
Oh, no.
not-
Okay.
But, they had the notice for the annual meeting
Uh-huh.
and listed the items to the discussion, and then had the, people who couldn't go give them their proxies to vote on for them.
Mhm.
So, they didn't list board member compensation. That was right after they had discussed the budget, and so it wasn't listed. But they used the 9 people that were there out of 29,
Mm-hmm.
and it ended up being 11, because 2 of those owners had 2 properties. So they still voted on board
On
member.
the compensation.
On board member compensation of half of the HOA dues as a discount, and used the proxies
To vote in
to
that favor.
vote, even though the people who were gone didn't.
Why
vote-
did they
didn't
leave?
Vote on that,
Why did the people leave? So I'll tell you, if you
Well,
have satisfied quorum at a meeting,
because most of them are absent, they're absentee owners, they don't even go to the board member.
well, and
meetings.
regardless of the facts, not everything has to be stated on the agenda for an annual meeting. I will
Okay.
tell you that, there's only a few things.
Can they
Change
just-
in budget, amending the documents, and removing a board member or officer. Those are the only three things that the statute says absolutely must be on the agenda. If something that comes up in the homeowner forum, then potentially they can vote on it as long as it's a decision for the homeowners to vote on. which we said were only a few things. So if somebody, for example, stands up at the homeowner forum and says, I want to fire the management company, that's inappropriate because that decision is a board decision. So if these things come up at the annual meeting, then they're inappropriate to vote on if they're not reserved for the homeowners to vote on. Your case, I don't know, because it depends on whether or not the homeowners are entitled to vote on board compensation.
Well, it's not in our bylaws. I looked at the bylaws.
So if it's not in the documents, remember, it defers to the board. So the board probably is the appropriate entity to vote on it. So, but we're gonna, well, let me move on, because there's a lot more coming here, okay? All right, anything else on that before I move on? Okay, so let's go to the next one. Fair treatment regarding financial and other association obligations, including the opportunity to discuss payment plans and options with the association before foreclosure is initiated. This is another change in the law. So this came down, HB 1276 came down 2014. And what it now requires you to do, a lot of this is already in your documents, in your declaration, but it provided a lot of other steps that you need to include when collecting delinquent assessments. One among many is you must offer an opportunity to enter into a payment plan. That is not something that was required per Colorado law previously. It is now. So that's just one of several things. So just realize that there are, again, the legislature is trying to promote discussion and opportunities, in this case, for homeowners to get out of debt and make sure that they can actually make those payments. Okay.
So before we would file a lien, we would have to offer a payment plan?
Well, the statute says before you take any action, and what most courts are determining action includes is a lien. And remember I talked about the 9 policies, and one of them being the inspection of record policy? There's also a collections policy. The collections policy must include all of these steps, including the opportunity to enter into a payment plan. So if you haven't adopted the collection policy, this is absolutely something that you have to have in place if you're going to try to collect delinquent assessments. Because I heard from my litigation department, they said the first thing the court asks for is, where's your collection policy? The second thing that they do is they make sure you actually follow that collection policy. Because many boards will adopt it and then shelve it and never even consult it. You have to follow the steps in your collection policy as well, or you're gonna lose in court. Doesn't matter if they're $5,000 in debt and they have never followed any of the procedures of the documents. If you don't have your collection policy in place, the court's gonna find against the association. Okay, number 5, receive all documents that address rules and regulations governing the community association, if not prior to purchase and settlement by real estate agent or attorney, then upon joining the community. So, I just put this in here because this is what CAI says homeowners are entitled to. Are you required as an association to provide these documents to homeowners upon purchasing? Have you done this before?
I didn't get them.
You didn't get them, okay. The law was changed for a very brief time to require associations to provide them proactively. That's gone now. You have no obligation to provide, proactively these documents upon sale to a new purchaser. However, if a homeowner requests that you provide these documents, so the seller, then you have to respond, again, within that 10-day, well, I didn't talk about the time frame. For inspection of records, it's a 10-day time frame, so you have to respond to that written record request within 10 days, or you can provide the records at the next meeting if within 30 days of the request. So, although there's no proactive obligation to send these documents out, you are required in response to a request by the seller or the seller's agent, and that could be their title company, realtor, whomever. Yes?
At one time, didn't the realtor have to provide?
The realtors do have their own obligations, but that's not what I'm gonna go into tonight. So the realtors have their own obligations. Okay. Number 6,
So a
yes.
potential homeowner can I request them?
They can,
Yeah.
but you don't have to give them to the potential homeowner. But the potential homeowner can ask the seller, please get these
And
documents
then
for
you
me.
have to give them a second.
Then if the seller requests, who is a homeowner, you must give it to that seller. Okay.
Are you gonna address, when you're selling your house, the documents that are required?
When you are selling your house,
Are you gonna address that there?
no, because there's no requirement for associations. I'm only addressing what's associations are supposed to do. So if you are selling your home, are you asking whether the association is supposed to do something, provide documents?
Yes and no.
Okay.
We have a deal where, our management company charges,
Sure, and
a
that's
lot of money for
for
providing
the
documents.
closing yeah, and that's for the transfer, it's the transfer work. And so most management companies do charge that, that's an independent obligation based on the management contract and the association. So that, if you have it in your management agreement, that is allowed. And it's actually, so, but there's no obligation for the an independent obligation for the association to provide any records, except upon request. So
But
look
it
at your
is a-
management agreement.
But it is a requirement, by the realtor to process the loan.
Sure, if they want records, they're usually requesting the association, so the association has to respond.
What's the association word meaning? Is that the HOA?
The HOA,
association?
sorry, the HOA.
Yeah.
Yeah, so if the realtor asks, and the realtor is not the agent of the owner, the seller, you don't have to provide it. You're not obligated at all. If the seller's agent requests it on behalf of the closing transaction, which is usually what happens,
Yeah.
this is typical, you are required to provide it.
But we would just turn that over to the.
And if the management company puts that together for you, they often have an agreement with the association to charge directly to the seller or the buyer that cost for them to put all the records together. So it is, but that's incumbent on the management agreement, not per statute.
I bet it's a high cost.
It has, and the legislature has been. The legislature every year has been thinking about capping it, but they have not put a cap on it yet. All right. Appeal to appropriate community leaders those decisions affecting non-routine financial responsibilities or property rights. The only thing I can think of here is usually it comes up, any kind of appeal process comes up through the architectural review process. That's pretty much it. There really usually isn't any other kind of appeal process. No, that's not true. Architectural review, there's an appeal process only if it's stated in the documents. If the documents don't provide for an appeal process, there is no appeal process. You can't go to the board if you don't like what the ACC decided on your behalf. But most documents do have an appeal process. The second potential appeal process is if there's a violation of the documents, the rules and regs, or maybe there's a pet violation or a parking violation, whatever it is. And let's say the association is going to fine the homeowner for this violation. If the board decides that they're not going to hear that violation hearing, so let's say the homeowner says, I want a hearing before you fine me, which they're allowed to have. Let's say the board says they don't want to, the entire board to conduct the hearing, and they appoint a hearing committee, a separate one. In that isolated instance, the homeowner, if they don't like the decision of the hearing committee, they might, if it's in your documents, have the ability to appeal to the board. So that's the other situation. I don't see it as often. What I usually see it is in terms of the architectural review process. Okay. So let's move on to what homeowners have the responsibility to do. And these I'm just going to go through really quickly, and just as a reminder, read and comply with the governing documents of the community. So obviously, everybody's supposed to read their documents, whether they do or not, who knows.
If they received them, and there's a question about
Well,
who or how
that's
or
my,
when.
that's my second
Thank you.
topic. So, there's no, again, obligation of the association to provide any documents to anyone, unless they request it. Okay? But, here's the one thing that the courts treat differently. So oftentimes homeowners, when they buy into a community, either the title company or the seller or somebody doesn't provide them the documents. They're the appropriate party to provide the documents upon sale. And usually it comes with a closing package, but every once in a while it doesn't. The courts say, and the legislature, well, not the legislature, just the courts say, that regardless of whether you get your covenants, also called CC&Rs, also called the declaration, the most important document, regardless of if you ever receive it, regardless of whether you read it, if it's recorded appropriately against your lot, which the developer does when they create the community, they subject your lot to the covenants. If it's recorded, courts say you have constructive notice of what's in those covenants. So even if you never received them and didn't realize that you couldn't have pets, but there is something in your documents, your covenants, that say no pets, the court's not gonna care if you move in with Fido and didn't do your due diligence. That's the only document that the court says you have constructive notice over, because it's recorded against your land and they want you to do due diligence and read those documents before you buy into the community. They don't apply the same standard to the bylaws or to the articles, and they certainly don't apply it to rules and regulations, which are adopted by the board and not recorded against your land. With rules and regulations, there's heavier scrutiny if somebody challenges it. So if somebody says, I had no idea that dogs weren't allowed, and the only prohibition against dogs was in the rules versus the covenants, the court's gonna say, well, did they receive notice of it? Did they get a copy of it? Did you adopt the rule? And after you adopted the rule, did you send it to the community? Because how do they know that this is prohibited unless it's stated in something that they received? So it's treated very differently than covenants. Just realize that. And I see a lot of boards adopting rules and regulations and then just kind of saying, okay, we did a great job, and then they don't even send them out. So how is somebody supposed to know that they're not allowed to do something or allowed to do something? You need to provide notice of rules and regulations, and you also need to provide an opportunity, a reasonable time frame to comply. So don't just adopt a regulation and then start enforcing the day later. Yes, sir?
Okay, I'm confused. If the rules and regulations are sent out at the time they were formed, and now we have a new homeowner, are we obligated to resend those to
No,
the?
I'm just saying when they're adopted or
Okay.
when they're changed,
Okay,
okay? And you should have a paper trail. And that's just rules and regs, not the covenants, just rules and regs. Okay? Yes?
Rules and regs cannot be written so that they
Are contrary.
are contrary.
Correct. So usually what are rules and regs, what they do, they clarify or they supplement the covenants. I'll give you an example. The covenants might say you can have a reasonable number of household pets. The board has the authority to define reasonable number. So the rules might say you can have up to 3 dogs. The board has the authority to define household pet. So they can say that includes dogs, cats, birds. So any board can adopt and define regulations based on ambiguous covenants, but just realize that a future board can then overturn that. So if you want to have something stick, if you want a specific cap on pets, if you want to prohibit chickens, whatever it is, you should put it in the covenants, because if you put it in the covenants, then only the homeowners can change that, not future boards. Okay. Oh, whoops. Homeowners are responsible for maintaining their property according to established standards. Sometimes they get the question of what does maintenance mean? So if it says you have to maintain your lot, the board has the authority to adopt the maintenance standard. They have the authority to adopt ambiguous covenants, and that's the only thing that I wanted to say on that. Yes, sir?
The meaning of neat, attractive, and harmonized.
That's, oh my gosh, yeah. It's all subjective. And I'll tell you, when it comes to architectural review standards like that, which all of them are like that, courts especially defer to that because they realize it is subjective. And there's no way to just define it any more specifically unless you're defining it for particular improvement. So for example, if your criteria in the declaration says before anybody installs any improvement, they have to submit it to the ARC to ensure that it doesn't, it's in harmony or it's aesthetically pleasing or whatever other general language. What the ARC can do is define specific requirements for particular improvements. So for example, if everybody in the community has only, what's a color scheme? I'm not good at this.
Earth tones.
Earth tone, natural, whatever. Yeah. You can have a color palette and say these are the acceptable colors for earth tones. If it goes outside of this, then you have to get approval. And the courts will defer to that. They will say, look, as long as it's not absolutely contrary to the documents, then you have the right to establish these guidelines.
As time passes.
It changes, maybe earth
no,
tone goes
the
to, oh, I was
property
gonna say.
changes from
Yeah,
72 flower pots and a couple of things.
right.
Does that affect the neat, attractive?
It doesn't, and that's why the courts are saying, we want you to put it in the guidelines to be flexible, so that in 10 or 15 years from now, if there's been a slow change, not just for architectural, but let's say pets, maybe one pet was reasonable. 10 years from now, everybody wants dogs, so maybe it's 3 pets. And that's why courts say it's important to have guidelines, so that they can be flexible and be changed to meet the community changes in the future.
But how do you get them to comply, property owners to comply with the neat?
With the specifics, with the guidelines or
If there's no really true guidelines.
if there's no true guidelines, it's gonna be a problem, because then it's like every decision is going to be different and there's no established standard. So courts want you to adopt them. If they don't, they still defer. They say, hey, is it still within the criteria? They're gonna defer unless the homeowner that's challenging it can say, look at all these other ones that are similar to what I'm proposing, and they approve those ones, but they didn't approve mine. So there could be other defenses that come in. Depends on the situation.
Commonly referred to as a can of worms.
It could be a can of worms. It could be. And I say the best board and the best association is going to, if something comes up regularly, they're gonna try to define it or establish some standards to then set an expectation. If they don't, they're gonna have a can of worms. Okay, number 3, vote in community elections and on other issues. That's just, remember, if they have the ability to vote and their voting rights have not been suspended, and suspension, just like serving on the board, has to be in the governing documents. There has to be something that says you cannot vote if you're not in good standing, or you're late in your assessments, or you're in violation. If you don't have those in that provision in your documents, they are entitled to vote. Okay. Oh, one more thing about that. Proxies, somebody mentioned proxies before. Homeowners have the right to vote in person or by proxy at any annual meeting or any owner's meeting. And so if you ever have a situation where a board wants to prohibit proxies, it is contrary to Colorado law. And limit proxies, do not allow that, even though there's nothing in the documents that says it's prohibited. Colorado law prohibits it. So they have the right to vote by proxy. Yes?
So it's outside of saying, hey, that's against the law, how can you stop that? If you-
Well, we usually, well, you know it as a board, you should know this, and if you don't have it in your documents, we always put in the documents. So if you're gonna rewrite your documents, always put in the proxy provisions that are per Colorado law. But if it's not there, then the boards don't know. So boards need to get educated, they need to come to the classes and they need to know the law, essentially.
All right, so you go before the board and you say, well, this is, I just read blah, 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 and it says you can't do that, and you're still doing it, so.
So you fine them, you don't allow it, if it's at the meeting, disregard the proxy, or whatever it is that's being challenged, don't allow it, or enforce against it, one or the other. So if you have somebody that's not complying with a document, what are your remedies? Fining them, suing them, suspending them from using the pool, whatever is established in the documents as a remedy for a violation, you enforce. What I usually see is boards not knowing that there is a violation, and even knowing, not enforcing it. So that sends a message to the community that I don't have to comply.
What if an owner brings that up to the board and the board's not in compliance?
Then the owner should remove the board. The owner should, if the board is not acting according to the documents, then it's up to the homeowners to get themselves elected and get the board off, get those homeowners off the board. Okay? All right. Next one. Pay association assessments and charges on time. That's obvious. That's something that, oh, wait, yeah.
Is on time defined in statute or by the
By the
homeowners
documents.
association?
By the documents and the policy. So
Okay,
it
it's
is in the
HOA,
declaration.
It's
It's
not.
document specific.
Okay.
Right,
So
it's not
to
per
each
statute.
association.
Absolutely,
Thank
yes. But the one thing about this is, no, I was gonna say about this, paying us in charges on time. I lost it. I blame you. No,
Thank you.
I had something, let me see, voting committee, management, okay, assessments,
You're losing the ability to ask more questions.
yeah, I don't remember. If it comes back to me, I'll come back to that one. All right, contact association leaders or managers if necessary to discuss financial obligations and alternative payment arrangements. Again, that goes to the payment plan that is now required for Colorado law. And you want to, what you really want to do is offer those opportunities. I think a lot of homeowners don't realize that if they don't respond and it gets to an attorney, it's gonna triple. Because every letter that goes out, every lien that gets filed, attorney's fees are added to that. So they're in a much better position to be able to pay off if they don't get to the attorneys. So it has to, I don't think associations do a really good job at communicating that. All you have to do is call the board, call the management company and say, we want to enter into a payment plan, and you'll be able to, it'll be a lot easier for you to do that pre-attorney than post. Because it's very difficult after the charges get added on. Yes, ma'am?
I know, I had a question back on number 4.
Okay.
We have a case where some years ago, the management company declared to that board at the time, that they were going to take all of the fines as due to the management company. So a late fine, in other words, if I did not pay my dues on time, I'm fined $25.
Yeah.
And that $25 now goes to the management company.
Because probably the management company charges for violation administration.
Well, they also charge $10 to send out the fine.
A lot of management companies do, that's how
Okay,
they
but
have
the-
their
The
money.
board never voted on it or anything, it just happened.
Well, then that's a problem, because if, whatever is either voted on, if this is in the management agreement, then they voted on it, because they approved it through the management agreement. If the fine goes directly to the management company and not to the board, and the board doesn't know that, then that's a problem, because the board is
So
supposed to.
it comes in and is income and then it goes out as an expense.
Yeah, probably because they might charge the same amount, or they charge additional, but if the board wants to, because these are really soft costs, or not soft costs, but they're not true revenue, they shouldn't be true revenue for the board. Fines should incentivize compliance. That's what the fines are for. If they're not incentivizing compliance, then they're not working and you need to sue instead, sue the person. But you definitely don't want to, when it comes to amount of fines, you want to have a fine that's actually gonna make a difference. You shouldn't have a $25 fine for keeping your RV on the driveway, because guess what? It costs more to get off-site storage than to pay that $25 every month. So they're just gonna pay the fine, they're not gonna comply. So you need to make sure that your fines are high enough to actually make a difference. Okay? So in that case though, yeah, maybe we should talk offline about that specific. All right, provide current contact info to association leaders or managers to help ensure they receive information. So a lot of times homeowners will move out of the community and they rent their lot, but they don't tell the management company what the offsite address is. That's shame on the homeowner. The management company or the board has the right to just keep sending it on to the address until they get that information. Ensure that those who reside on their property, e.g. tenants, relatives, friends, adhere to all rules and regulations. The only thing I want to say about that is the homeowner is who you go after if the tenant is in violation. The tenant doesn't have the contract with the association. The homeowner does. So if the tenant is violating, you pursue the homeowner, you find the homeowner, you exercise whatever other remedies you might have in your documents against the homeowner. Incumbent in that though, a lot of tenants don't realize that they're breaking the rules because the homeowners don't do a great job of giving them the rules prior to them leasing the property. Yeah.
In our document, it says that the owner has to provide a condition of the lease, and if they don't,
It's a violation, right?
well, no, it's a condition of the lease,
Uh-huh.
and that the
That they,
lease must be in writing. Now, the question becomes, who should receive that lease document?
so that is dependent, that's document specific. So I'm glad to hear that the actual documents require this, because most declarations, most governing documents don't even require that. If it's not specified who a copy of that lease goes to, and it's not a requirement, most documents will say that the board has the authority to adopt rules and regulations or administrative rules and regulations, which would also apply to leasing. So I would say that the board probably has the right to adopt rules that are related to leasing, to say a copy of the lease should be provided to the association, just to see if that condition's in there. It is document specific, but most of them allow that. Okay, and the other thing too is for adherence to rules and regulations, you go after the homeowner. If the homeowner doesn't comply, many associations are now writing into their documents that the association can have the authority to evict the tenant. Now, we've never had to actually exercise that, but just having the language in the documents does wonders. So even if, and you would have to have that in your declaration or your CC&Rs to be able to actually exercise or threaten to exercise that right. So if the homeowner's not doing it, then the association has the right to do it. If you put it in your comments. Okay, community leaders, that could be board members or managers, have the right to expect residents to know and comply with the rules and regulations of the community and to stay informed by reading materials provided by the association. So yes, they have the right to expect this, and whether it happens, again, is not necessarily commonplace. But as we said initially, to the extent that you can over-communicate, put it in the newsletters, provide email blasts, do whatever you can to try to get that information out, that's actually positioning you as a board and association in case it ever gets challenged, whatever your decision is in the future. You say, we sent all this information out and they chose not to read it or come to the meeting. So at least you're protecting yourself in that way, and hopefully more homeowners will actually read the documents or read those newsletter blasts. Respectful and honest treatment from residents. Yeah, you're entitled to have that, and I'm just going to say that if you have somebody screaming at you, then you can adjourn the meeting. If they're screaming in the middle of the meeting, one tip that one thing you want to do is you want to put that in the minutes. So if Mr. Smith is screaming at a meeting or disrupting the meeting and monopolizing the meeting, then say, Mr. Smith, the first time, this is out of order, you've already had your opportunity to speak, or whatever it is, move on. If he does it again, say again, Mr. Smith, blah, blah, blah. And then if it happens again, say we're going to adjourn the meeting, or we're going to ask you to leave, whatever it is. Get it in the minutes. And the reason why is if you ever have to take more aggressive action because of behavior by anyone attending the meeting, now you have that paper trail. It's in the minutes. So definitely use that. The other way you can stop the screamers is if you know it's going to be a particularly hot annual meeting and somebody's going to be challenging and screaming about whatever, have a microphone in the front of the meeting and say, anybody who has any comments, we ask that you come up and speak to the audience, face the audience, and use the microphone. Oftentimes they do not want to engage in that behavior if they know that they're going to be screaming a microphone. Some boards will say, we want to make sure, management companies, if they come screaming to the management companies, we often say, pull out your phone and say, I want to record this to make sure that I get your concerns. And that way, again, they don't want to be screaming and using foul language on a recorded document. So there's ways to address this, but ultimately, if it gets to the point of harassment or verbal abuse, or you fear for yourself, you ought to be calling the cops and you ought to be talking to the attorney. Because then that becomes a cease and desist kind of issue. Yes?
I thought it said somewhere that it was not legal to record a board meeting or an HOA.
It's usually not allowed per your policy. Remember those 9 policies I talked about? One of them is conduct of meetings, and that's what I was going to talk about next. In the conduct of meetings policy, you can say, as a regulation, that no meetings are allowed to be recorded. And that's because, and if they are going to allow recording, you have to give a copy of your recording to the board after you record it, just to make sure that things aren't taken out of context, because oftentimes there's 2 consequences about recording. The first one is if somebody records it and they can take a piece of it and blow it out of context, so that could be an issue. The second thing is, if they know, if the if the homeowners or the board members know that they're being recorded, they might be inhibited from speaking freely, and we want them to speak freely. And so I see goods and bads, but if it's not prohibited in the policy, then they can record, because there's nothing per statute that says you can't record.
But they have to provide a copy? to
Not,
somebody?
no, but that's what you wanna write into your policy. If you're
Oh,
gonna allow it, then you want to say, we're gonna allow it, but you need to provide a copy. So that it's the exact, they can transcribe it, and we know what was actually said and stated.
Okay, well, I thought I read it in the statutes that it said.
Not in statute, no.
Okay.
Okay, conduct meetings in a positive and constructive atmosphere. Your conduct of meetings policy, one of the 9, should have ground rules. And if you think that there's anything that's gonna be hotly debated in those meetings, then you should bring that conduct of meetings policy to your meeting and read those ground rules in the beginning. Things like, you have to be respectful, you have to address your comments to the chair, you can't speak for more than a certain number of minutes, you can't take somebody else's minutes, you can't interrupt, you can't use foul language. All of these things should be in your ground rules for a meeting. Personal privacy at home and during leisure time in the community. So board members, unfortunately, if you're a board member and everybody knows where you live, sometimes they come to your homes, unfortunately. So you can certainly communicate that you don't want anybody coming to your homes, and if they have issues or questions, come to the board meeting. But the thing that the statute changed, that some board members don't like, but unfortunately this is out there. Remember the records statute I talked about, 317? One of the records that you are prohibited from providing to homeowners is their emails or their phone numbers to other homeowners unless they consent. So for example, if you have a community directory and a homeowner consents and says, I want to allow my email address and phone number to be provided to other homeowners so we can, build community. So if they agree to it, then you are entitled to provide it. If they don't, you better not be providing that information. However, it excludes board member emails from this. Homeowners have the right to board members' emails addresses, not phone numbers, but emails. So that's where the privacy is gone when it comes to board members. And that's because they want, I think the situation is there might be some buffer, maybe with a management company, and maybe homeowners don't feel that the board is getting that information directly. Maybe they feel it's being filtered, so they want to have the ability to send it directly to the board. Doesn't mean you have to respond, it just means, and I would usually say respond with very professionally and say, okay, well thanks for your comments, come to the next board meeting. You want to have that discussion in the board forum versus one-on-one. But if you have an email address, doesn't say you have to have an email address, but if you do, then it's open for, it's available to other homeowners upon request. They don't have to publish it, but it's upon request. We also always say, don't use your personal email address for board business. There should be a, HOA president@gmail.com, something that's just used for board business, simply because if for whatever reason, unfortunately, you get sued, the association gets sued, then they can take any emails in the discovery process that any kind of email exchange, if you use that email address for board business in any way, they're going to be able to discover your personal emails or your work emails. So you want to try to differentiate it and distinguish one from the other. The second reason why is, again, for records, what's now the law is if you conduct email votes, if you conduct email business, so you as a board member send an email to other board members and it's, you want to hire a management company and they respond via email. So you're taking action outside of a board meeting, you're doing it by email. The law now says that all written communication, including emails, that lead to that decision by email are available for inspection. So again, that's new, that's per that statute I was talking about. And if you board members tend to be informal, so you need to be more regimented. If you're gonna vote on something by email, it should clearly state, this email thread is for the sole purpose of discussing and voting on this particular action. That way you can clearly divide the business emails versus other types of emails. But if you don't, well, not if you don't, but others are available for inspection. So another tip is write your emails in the same way that you would speak those comments at a meeting. Don't write them in any other way, because again, so just be regimented, just speak professionally or write professionally, because you'd be surprised how many emails are blown up on the screen at an annual meeting or a board meeting or some kind of recall meeting based on some offhand comment that probably has never been said before, but it was used for a particular purpose during that recall meeting. So just act professionally. Okay, take advantage of educational opportunities, training workshops directly related to the responsibilities as approved by the association. Again, this is a CAI requirement. None of this that I'm talking about as the list is Colorado law, but I'm talking about what Colorado law says in conjunction with this. So in this respect, Colorado law does require many associations don't know this, does require the association on an annual basis to provide some kind of education to the homeowners. This became law like 4 or 5 years ago. And what that means, the education itself has to be on HOA governance or rights and responsibilities of homeowners, something related to the HOA. You're not required to spend any money on this. So for example, the method by which you give this education is up to you as a board. So as an example, you could take an article from our website, for example, that discusses HOA governance or rights and responsibilities, like we're talking about today, and circulate that in your newsletter or with the next annual meeting notice. That will satisfy it because you're providing an educational piece to the homeowners. If you're going to do that, then make sure that you state somewhere in that article, in the beginning, this is intended to satisfy the annual education requirement, because there you've paper trailed that you've satisfied the requirement. Other ways to do it, you can have a lot of associations ask us to come to the annual meeting and speak for 15, 20, 30 minutes on some kind of topic of governance. So in that case, you are spending money on it, but that's okay because I'm making money on it. So, but that's another way you can comply, okay? Other ways, I mean, there's all sorts of things you can do, but you don't, I just want to say, you don't have to spend money, and a lot of associations are nervous about that requirement. Now, what's funny is, this is talking about board education, right? Boards taking advantage, so such as board members coming to this meeting, to this training. The statute originally was written to require boards to be educated, but they took it out. So it's a little bit counterintuitive because the board is the one that's running the community, but they're not required to be educated. And I think the reason why is because if board members thought that they were required to also attend classes, you're going to chill the potential pool of people who are going to serve on board. They're like, we're already spending so many hours being volunteer board members. Are you really going to require us to get continuing education? So there was a lot of pushback. But I do have some associations that write that into their bylaws because they think it's important. And again, most of these classes, they're all free. So it's not a cost to the association. It's just time spent. And the time spent should be for your benefit and also for the benefit of the community. Okay, community leaders have a responsibility to fulfill their fiduciary duties to the community and exercise discretion in a manner they reasonably believe to be in the best interest of the community. Now, in the beginning of this class, I talked about the board having to change their hats and wear different hats and act according to a particular standard. That's what this standard is right here. And in most classes, I open up with this, and I'll just talk about it briefly here. As a board member, you owe a fiduciary duty to the association, to the corporation, not to the homeowners, not to the other board members, but to the association, to act in good faith, prudently, and in the best interest of the association. Each one of those are separate. Good faith just means don't act maliciously. Don't act in bad faith. Don't, and usually when it comes up is a particular board member or a homeowner is not as supportive as others, and you all of a sudden are treating them differently. You're making them jump through additional hoops to get an ARC submission approved. or you are making them do more to get records than any other homeowner. That's in bad faith, and that you will lose if you're doing that, and they can show it, that you're treating others differently, or you're picking on them. That's one of the main claims against associations today, is you are picking on them. So that's in good faith. Prudently just means ask a lot of questions, conduct due diligence, make sure your decisions are informed. And the way you do that is come to the classes, ask attorneys for opinions, ask the accountant to provide reports, or the management company, whomever. Paper trail your decision-making process, particularly if you're spending a lot of money, because those are the decisions that are getting challenged. Don't enter into a $2 million, $3 million contract without having your attorney review the contract, for example. Or don't make a huge decision to change the color scheme of the community without getting input or feedback from the homeowners. That's going to be a big challenge. Okay? And then finally, your decision has to be in the best interest of the community, and that just means not in your best interest. Separate your interests. Oftentimes your interests align with the associations, but many times they don't. And I'll give you one example. We had a couple of board members in another association that voted against a special assessment because they knew that they couldn't pay for it themselves. That's totally inappropriate. You have to, even if it is against your own interests, you have to act in the best interests of the association. Sometimes that's difficult if you're enforcing against your neighbor or your good friend, because you have to treat them the same way as that troublesome Mr. Smith that comes to every meeting. You have to treat them the same. Okay? All right, so if you act according to that standard, good faith, prudently, and in the best interest of the association, then what statute says is you're exercising your business judgment right to make those decisions, and you as a board member will be protected from individual liability, even if your decision turns out to be wrong. So, and that's key. They want to defer to the board members who are acting according to that standard, again, because if board members thought that they could be liable for every single decision they made according to that standard, again, homeowners won't serve on the board. So you're protected as long as you can show that you acted according to that standard, which is why you want a paper trail. Do you have a question?
Yes, it's coming back on that other thing I said. Is it in the best interest of an association for the board members who want to be compensated for board member duties?
Well, it could be. I mean, I don't know if it's in the best interest of the association. Let's say the only way that somebody's going to serve on the board is if they're compensated.
Okay.
That could be, if no one else is willing to serve, that could be the sole reason why it might be in the best interest. Because if you don't have a board that's willing to serve voluntarily, then it could be appointed to a receiver who is just collecting assessments, not a homeowner, doesn't have the same interests. But most documents prohibit compensation, so just realize that. And if you're compensated, you are no longer protected, or you're arguably no longer protected by that business judgment rule, because all of a sudden now you're an expert, you're being paid for your decisions. So if you choose to be compensated, you might lose that protection. Yeah?
The expression wanton omission has come up quite a bit.
Okay.
Can you
So
explain?
that's malicious, right? So if they willfully know they're violating, or if they have information and they don't share it, and failure to share it is not in the best interest of the association, that will expose the board member to liability. So it all depends on what it is, if that information is available elsewhere, if it really is germane to whatever the issue is. But I will tell you that it's very difficult to hold a board member liable for breach of fiduciary duty, because again, the courts want to defer. They don't want to second guess. So 9 times out of 10, board member, unless they're acting very egregiously or grossly negligent, is not going to be held personally liable for that decision. So they have to be almost extremely willful. Well, yeah.
Well, in some HOAs, they want to have very strict enforcement, and some decide not to
Less strict.
enforce the restrictions, which are they required to enforce?
Okay, that's a great question. So I think the level of enforcement is up to the association. But if there's a clear violation, they're required to enforce. So here's the difference. Some associations will have management companies or board members drive through the community and have inspections. And that's how they find out what the violations are. Others will enforce based on complaint basis only. I think both are valid. But if a known violation occurs, you do have a duty to take action. What that action is will depend on the violation. So most of the time, 9 times out of 10, it'll mean you need to enforce it because it's brought to your attention and it's a clear violation. Sometimes it means no enforcement, depending on the situation, yeah.
It says that, the board members are required to enforce our documents, restrictions, blah, blah, blah.
Uh-huh.
If a board member sees a violation and ignores it,
I think that's fine. If they don't complain, if they see it and it's not, if the board hasn't said as an adopted an enforcement strategy, and if the board says, if you as a board member see a violation, you are required to submit that violation in writing and enforce it like any other complaint submitted by another homeowner. And the board is acting contrary to that, then I think there's a problem. But if it's, you see it and you don't enforce it, and only you see it, and you decide not to notify the rest of the association about it, I think that might be okay. It really will, it might be okay. It depends. It really depends on the board philosophy and whether or not that board member is adhering to that philosophy. The problem is, if it's this, because when it comes to a complaint basis, it really is, that's what the community wants. If no one's complaining about it and no one has submitted it, then why are you as a board member required to go out and see it and submit it? Yeah.
if it's only ignored
In one area?
by the neighbors, but
Yeah.
you report it if it's not a neighbor. Are you showing favoritism?
I think you could be, yeah, so that changes the facts.
That
So if
changes-
if there's preferential treatment, that is an issue. Particularly if it's, like again, if it's, you're acting in the best interest of that neighbor, not the association. Or you're ignoring your own violation, or you're only going down one street and not other streets. Yeah, that changes the facts. But if it's a, hey, I noticed a violation, but I don't report it, I think that alone wouldn't expose the board member to liability.
To strengthen that,
Mhm.
would that need to be in the bylaws? That
To
it's
strengthen
required?
what? The enforcement strategy? It should be in your enforcement policy, one of the 9 policies.
Okay.
And that should be clarified, whatever your enforcement strategy is. And some of them actually say, we will only enforce based on a complaint basis. So if no one complains about something, we're not gonna enforce it. So, and I would even say, even if somebody complains, but they don't sign off on it, and there's no way for the board to independently verify it, I'd say you shouldn't enforce it, because you don't have a witness.
Okay, I thought I read in the CCIOA that a valid photograph or something like that of a violation
Is
is
enough.
credible to eliminating the cat and mouse game with,
I think it's the best form of evidence, yeah. So that is independently verifiable, you have the picture. So,
if one was submitted to the management company, this date, here's the violation, that should be, not have to be,
investigated, because
right,
it's,
and is
yeah.
considered a violation. So then why does the board have to sit and vote on it?
I don't think they do if the evidence is there. What the statute says is, if investigation is necessary, there needs to be some kind of impartial investigation process. But if a photograph is the most objective evidence there is, it's not somebody's word, it's just a picture, I think that's enough.
Just-
It's a violation, yeah.
You don't have to vote
It's a
on it.
picture of a violation. If it says sheds aren't allowed, and there's a shed on property number 1, 2, 3, I think that's enough.
Just trying to clean up loose ends.
All right, okay.
But-
All right,
Sorry, but, so if the shed has sat there for a year and nobody's done
That's
anything
different.
about it.
That's totally different. So, when I said, if there's an enforcement, if there's a violation, you have a duty to take action. The action might be to enforce, but it could be something else, which is not enforced, because it's no longer enforceable. So if you tell me there is a fence that's been up for over a year, that the board knew has been up for over a year, and now they're gonna try to take it down, I'm gonna tell them don't try, because the statute of limitations is run. So you have to take action based on the violation. You don't necessarily have to send a letter or sue or enforce it. You just have to take the appropriate action as a board. Yeah.
You're talking about the fence, that's on private property.
Yes, not on common area. There's other arguments for common area fences. All right, let's move on. All right, number 3, understand the association's governing documents and become educated with respect to applicable state and local laws. Again, we already talked about that, but now it's the board members that aren't required to become educated, but it's appropriate, and I think it's satisfying your fiduciary duty to make informed decisions if you do become educated, and you absolutely need to review your governing documents. If you don't know what's in your bylaws, you'd be surprised how many things are in the bylaws that the boards don't know about. And so for example, many bylaws will say you have to have an annual meeting on December 1st at 7 p.m. If it says that in your bylaws, you have to have the annual meeting on December 1st at 1 or 7 p.m. or whatever it is. Otherwise, that's a technical violation. One violation is not going to expose you to liability. But if you have somebody who's trying to make an example of you and saying the board is terrible, they're mismanaging the community, cumulatively, if you are causing or have technical violations 5, 6, or 7, you don't meet quorum, you don't physically post a notice in the community, you don't hold the meeting at the right time or in the right location. Cumulatively, this could expose you to liability for breach of fiduciary duty. So I said originally that it's usually only egregious violations of the boards or gross negligence that's going to expose you to liability. Many technical violations amount to that. That's what the courts say. If they see all the areas where you don't dot your I's or cross your T's, that's going to expose you to liability. So know what's in your bylaws, and if your bylaws are contrary to Colorado law, you should be amending them to be in compliance. Okay, number 4, establish committees or use other methods to obtain input from owners and non-owner residents. I mean, I always think that you want to have everybody's input. It doesn't matter that you're not an owner, you could still give valuable information. And if the committees use anybody who wants to be part of it, you might be ignoring great talent out there if you don't allow tenants or spouses of owners or whomever to be on these committees. Number 5, conduct open, fair, and well-publicized elections. We already talked about who can be on the board and the qualifications for being on the board. One thing that many boards don't know is that another change in the law was if you have a contested election, that means more people running for the board than positions open. So it's contested, which probably never happens. But if you do, it has to be done by secret ballot. That's a new law. Most associations use secret ballots anyway, but it must be done by secret ballot if it's a contested election. Okay? So that's the other thing. The third thing is you need to have only neutral third parties count ballots. And they don't define neutral third parties other than saying it can't be a candidate running for the board and it can't be a board member. So other than those two, what's neutral? Management company probably isn't neutral because they probably have an interest on who serves on the board. Really? Attorneys as well. They probably want this board to serve and they don't want the other board that's trying to recall them to serve. But if you choose somebody from the audience, 2 or 3 people who are not related to the candidates or board members themselves, then that should be enough to be the neutral third party. Welcome and educate new members of the community, owners and non-owner residents. I think that not enough is done with tenants to really minimize the problems that associations have with tenant behavior. We already talked about what I feel is the duty of the homeowner to provide the rules and regulations, and in some cases it's required as part of the lease or whatever. But the association also should, if it has a lot of tenants in the community, should do something to address that. And I have one association, I think this is a great idea, they say it's working really well. They have a lot of tenants, and so what they've done is they've appointed what they call a renter ambassador. So this is a landlord owner who serves a position, it's like a committee. And that person is then charged with welcoming the tenant, reminding them that, hey, the rules and regulations are available on the website, who to contact or discuss if they have any questions. And that, again, is intended to minimize future disputes with the association and the tenants. Encourage events that foster neighborliness and a sense of community. You know, the more community you have, the less it's again intended to both encourage homeowners to be part of the decision-making and feel more of as owners and part of the community, and it also is an opportunity for you to, again, over-communicate what your goals and what your wishes are, so as to paper trail yourself for future challenges. Conduct business in a transparent manner when feasible and appropriate. We already talked about the records. You have to provide records, that's transparent. You have to allow homeowners to attend meetings, that's transparent. You have to provide more notice now, that's being transparent. There's a lot of other things that you can do to be transparent. One other thing, it's not in here, but somebody mentioned in the beginning, this gentleman in the yellow, that they have everyone leave after they've had their input at the board meetings, right? So the statute says you cannot close board meetings from homeowners unless you're in executive session. So executive session is in Kiowa. I can't remember off the top of my head what the specific statutory site is, but I can tell you there's only 5 or 6 categories. So when you get Kiowa, when you download it from our website, all you have to do is search executive session and it'll come up. And there really is only 5 or 6 categories for which you can go into executive session. And what I find boards doing is they go into executive session for the wrong category, or they go in for the right category and then continue to discuss other business that's no longer appropriate for executive session. I can give you a few of them off the top of my head. I might be able to give them all. But number 1, attorney-client privilege. So if you have an attorney at the meeting, you can close it off. It's a privilege to close it off from homeowners. If you are reviewing advice or opinions from the attorney, you can close it off. If you are talking about discussing a management agreement, that's the only agreement you can go into executive session for. You can't go into executive session to talk about the attorney agreement, or the landscaping agreement, or the fence agreement, whatever it is. But if you're discussing the management agreement, you can go into executive session. Who knows why? They just pick that one. If you're discussing misconduct, and that means criminal misconduct, you cannot go into executive session for a regular violation hearing. So a lot of associations do. They go into executive session because they feel this is private, and we ought not to have homeowners observe this. But the actual legislative intent is that homeowners have the right to know what you're doing to enforce the covenants. However, if the situation falls under another category of the executive session, it might be appropriate. So for example, you can't have a blanket rule saying all covenant violation hearings have to be in executive session, because that's inappropriate. It's not one of the categories. But if somebody comes to you and they know that they're going to have a hearing and they know that homeowners are present, and they come to you and they say, please don't open this violation to the general public, the general membership, because the only reason why I didn't comply is because I am disabled and I need this pet or this dog to accommodate my disability, or there's some kind of private information that they don't want to allow others to hear. One of the categories of executive session is if it invades somebody's privacy. But you can't use it as a blanket rule and say all violations, but if somebody comes to you and gives you information, then you as a board can make a case-by-case determination. Okay, this is violating this person's privacy, we're going to close it off. but it should just be on a case-by-case basis and not as a blanket rule. Okay, yes?
Are those records open for inspection?
So previously to the records law being passed in 2014, yes, which is why we said don't take any minutes in executive session because it's going to be open.
No, the violations.
No, under the new law, the only violation logs that you are, or records that you are entitled to see are those that affect your property. Prior to the law being passed, you could ask for copies of everybody else's. You're no longer allowed. So these are key differences. You need to look at that statute. Okay, allow homeowners access to appropriate community records. We already talked about that. Review that statute. Make sure you have your inspection of records policy. Provide a process residents can use to appeal decisions. We already talked about that as well. This is just, again, the duplicate side. Now it's the responsibility of the board members to provide this process. But that's an ideal. That's not required by Colorado law. Again, appeal processes are only driven by your governing documents. So if there's the right to appeal in your documents, then you have to give that appeal. Make covenants, conditions, and restrictions as understandable as possible, adding clarifying lay language or supplementary materials when drafting or revising the documents. We revise documents all the time, and one of the main reasons why people come to us is not necessarily because they're not compliant with Colorado law, but because they can't understand them. There's so much legal ease. And so I think even though it's not a legal requirement to do this, this is a great point. The easier it is to understand, the clearer the language is, then compliance is easier as well. So try to make it as easy to understand as possible. Don't use legalese if you don't have to. If you're in the process of amending, make sure that that's one of the factors that's in consideration. Yes, sir?
We have some residents that should we send out violations bilingual because we've got some that really don't understand.
Yeah, I think it depends on your community. So if to the extent that there is, I would say as a practice, yes, if you know, then you should do it. It's not required, but to the extent that the makeup of your community has more residents that need that, then yes, I think it's a good idea. It's not required, but it's a good idea. And I do know that a lot of management companies are taking that into consideration when they have their form templates. They do provide that as well.
Are they required to do that?
No, they're not required, and so that's the thing. It's more of it's the right thing or the best practices depending on the makeup of your community. Provide complete and timely disclosure of personal financial conflicts of interest. Okay, so this is per Colorado law, and this is one of the policies. One of the 9 policies is a conflict of interest policy. What is a conflict of interest? Can you guys tell me what that means?
If I'm a window installer?
As a board member and you want the association to hire you, right? Okay, so you're getting some kind of financial benefit through a transaction with the association. 9 times out of 10, it's a board member who has a company, a landscaping company, and they want the association to hire it. That is a conflict of interest. That does not mean that it's void or unenforceable. You can still enter into that contract. Because it could be a great contract, could be better than all the other contractor bids out there. But what is required is the board member to disclose that. And that's for your conflict of interest policy. The board member must disclose it to the remaining board members, and a majority of the disinterested board members must vote in favor of that transaction. The law changed one thing though. So previously, the board member with a conflict was required to recuse him or herself from voting or even participating in the discussion after disclosure. The law changed and now allows the board to decide what they want to do. So in your conflict of interest policy, it should say, board members with conflicts of interest must disclose to the remaining board members. And then it should say whether or not that board member after disclosure must recuse themselves from the voting and not participate in the discussion. That's left up to you now per the statute. But it has to be in a policy and it has to lay out your decision. Okay? Do you have a question?
Yeah, I am a board member, but I'm also a real estate agent.
Okay.
And my neighborhood is one of the neighborhoods that I send out a postcard saying, here I am, you know, list your house with me or sell your house, whatever.
Okay,
But
that's not a conflict.
that was my question.
It's not, because you are not getting money from the association based on your, sending out
Right.
anything. So there could be all these situations where you feel the need to disclose. Now, in that case, it's not a conflict, but still, it might be prudent to say, and I'm a board member. You know, I mean, it just, if people ask, because they're gonna be wondering, are you using association materials to send out this information? I mean, in any way are you tied to receiving some benefit from the association by being a board member and also a realtor wanting to list their
I
houses?
was reluctant to put that on the postcard because I didn't want it to seem
Well, no,
inappropriate.
and I understand that, I'm just saying that in response, I mean, if it becomes, if people start asking questions, or
Mhm.
even, then you might want to, I'm trying to
Okay.
figure out the scenario, but you don't want anybody thinking that you're using resources of the association to benefit yourself, in other words. All right, I think that is it. So, we have, I don't know, I think that's a little bit slow. Yeah, we have 9 minutes.
You did a great job.
We have 9 minutes. Thanks, everybody. This is people advice for 9 minutes. I'm opening up to Q&A. Let me get this gentleman first.
You addressed my question, but I'm sorry, I must have dozed off.
Oh, really?
The situation was, when you're voting on a homeowner's, let me give you the scenario. A homeowner was found in violation and was given the time to correct that violation.
Yes,
After that period of time, the violation was not corrected.
yes.
We send out a notice that says, for example, on August 1st, we will fine you $25, it's not corrected. Our next board meeting is July 20th. You have the opportunity to